Thank you, Mr. President. My delegation has taken note of the joint study on global practices in relation to secret detention in the context of countering terrorism compiled by working groups of this Council. Mr. President,
at the outset, my delegation wishes to update the information contained in the report with the contemporary developments in Sri Lanka, in particular, the recent decision by the government to roll back the emergency regulations. As we stated during the general debate on item 2, with the ending of the terrorist conflict, the government of Sri Lanka has now commenced the process of scaling down the emergency regulations. As a first step in the direction, the government in early May this year decided to withdraw a substantial segment of the emergency regulations and modified several others. The government of Sri Lanka does not wish to indefinitely continue with the emergency regulations. The rollback of these regulations at this juncture is only the beginning of a process which will be continued as and when the ground conditions become conducive to their future relaxation. Despite these developments, my delegation wishes to make some observations on the substance of the section dealing with Sri Lanka. The report refers to concluding observations on Sri Lanka made by the Human Rights Committee in 2003, and one observation made on the issue of torture has been taken out of context in the study to put special emphasis on supposed secret detention in the country. We have also noted that some assertions in the report on the question of detention are almost entirely based on hearsay. In this regard, we wish to emphasize that all detention in the context of countering terrorism had been made within the legal framework that governed such detention. Whether it be arrest under normal law or anti-terrorist legislation, legal safeguards are firm to ensure the rights of suspects. Illegal arrest and detention tantamount to infringement of our constitutional chapter on fundamental rights, and any infraction of these process rights would give rise to the intrusive jurisdiction of the Supreme Court. The remedy of habeas corpus is acknowledged to be a bulwark against abuse of executive powers of arrest and detention, and this constitutionally Sri Lanka is an efficacious remedy for any illegal detention. According to the emergency regulations that have now been scaled down, detention has to be at an authorized place that has to be gazetted, and the places of detention are thus in public domain. Moreover, the magistrate is notified of the detention within 72 hours, along with simultaneous notification to the kith and kin immediately upon arrest, and a presidential directive to this effect has also been in existence. Any violation of these enactments exposes an errant state agent to visitations of prosecutions in addition to a civil suit, and the panoply of safeguards and remedies demonstrate that incommunicado detention has not taken place in Sri Lanka, and under no circumstances would Sri Lanka derogate from this state policy and practice. Mr. President, quite contrary to the assertions in the report, the surroundees and detainees were not held incommunicado or in secret facilities. A legal regime has been put in place for their rehabilitation and release. The emergency regulations of 2005, as amended recently, governs their status. Restorative justice initiative has culminated in 8,225 of the surroundees and ex-combatants undergoing rehabilitation with a view to release and reintegration into civilian life and fruitful means of livelihood. 2,322 of them have already been released, and 1,314 of them with high degree of involvement in crimes would be prosecuted with indictments expected by the end of the year. Even with regard to them, the government of Sri Lanka would launch prosecutions only when there is evidence of a higher degree of culpability. All have had process rights such as access to legal counsel and to their families. We would also like to notify that a dedicated team of attorneys has been especially assigned by the Honorable Attorney General to expeditiously deal with cases pertaining to the detainees in order to accomplish the transitional justice process, and thus this program will draw a close by a final